When we structure estate planning and do not use a revocable living trust, our plan is going to be designated around what we call beneficiary designations, and we will leave behind a last will and testament. But our goal, our main plan, is that we don't end up using this document. We want to structure assets to transfer outside of probate, and when we achieve that, we do not end up needing to use a will. But for all purposes in estate planning, we want you to have a will because the purpose of the document is to make probate easier, faster, and cheaper if you do end up having to go through it. This video in particular is a shortened video regarding a last will and testament when you do not utilize a trust. If you do utilize a trust, there's going to be a separate video for something called a pour over will. We want you to watch that one instead. So for this video, we're going to go through a more simplified version of the last will. In the full video that's available on the website, it is going to cover these provisions in much more depth. So as you might have questions that come up after this one, please feel free to reference that video. In terms of the last will, there may be several sections that are unique to you and to your family and to your planning. I'm going to go over the common sections that are included in a will document. For purposes of the will, you will typically receive a table of contents. So what I will do in this video is simply go through what I'm seeing here in this table and explain some of these key sections. So at the outset of a will, you're going to see some basic information. You're going to see your name as an example, any other legal names you may have used, for example, like a maiden name, and where you live. And if you are married, if you have any children, there will be an article at the very beginning of the document identifying those people. And there will be names and dates. So please just make sure when you review that that information is accurate. And if for any reason there's a typo or something is incorrect, please make note of it and we will update that throughout all of your documents. Now, what is commonly going to be the first substantive section of a will is going to be called specific and general gifts. And this is going to identify what we call specific gifts, which might be a specific asset I own, like a vehicle or my business or my house that is going to a specific person. Or it could be a dollar amount. Maybe I want $10,000 to go to my niece, and everything else that I leave behind is going to go to my children. If you have any specific gifts, they will be listed here. So please make sure to review those closely. And as needed, we can add more gifts, we can change the gifts you've structured, etc. The next section and the following sections that are not highlighted after it, you're going to see what's called section 2033 in this document, disposition of tangible personal property. This is setting up a process that we want you to give some thought to about what happens with all of our stuff. When we pass away, decisions are going to need to be made about all of my furniture, all of my clothing, all of my forks and knives. One of the documents that we're going to provide you in the planning process is simply a template. It's usually in a Word document format called a personal property memorandum. What this allows you to do is make any decisions regarding important items that you have, such as this piece of jewelry, and maybe where you would want it to go, such as to a particular person. Or maybe I want to generalize things and just say, all of my furniture, sell it. All of my clothing, donate it to this organization. So what your will is referencing here is if I ever create a personal property memorandum, those are my instructions, they are binding, carry it out. But the remaining sections here cover some things like, well, what if I forgot to include an item? Well, your executor, your personal representative will make those decisions for you. Or what actually all can I include in a memo? Well, that's what that definition section for that's listed in 205 there. So feel free to review these sections and then review them in conjunction with that personal property memorandum template that we share with you. And at any time in the future, if you want to fill that out, you just fill it out. You can type in answers, you can handwrite answers, you date it, you sign it, and you send it back to us. And you can update that document as many times as you want for the rest of your life. Article 3, what's called residue, is whatever is left over after I pass away. So Article 3, my residuary estate, is going to say where I want everything that's left over to go. And commonly, it may say something like, I want everything to go to my spouse or to the kids or to my siblings. So make sure that whatever your plan is written out there. And that's typically very short and simple. What's called remote contingent distribution is essentially here a backup plan. We always have to plan for the possibility that the people we want to leave things to, they might not be here. And so we include a backup plan. In this case, it's in Article 4 that's going to say where everything goes after these main people. And that could be to friends or family, to charities, to a combination. So, whatever your intentions are, just make sure that they're clearly written out here. A lot of documents may contain a default provision, which is basically how we avoid things under Colorado law, where we might just say, instead of naming all these specific people and places, I just want everything to go to my family, which is going to be your next of kin. We're always going to identify, in this case, Article 5, any specific people that we're installing to carry out specific responsibilities. So in 501, what we used to call the executor, we have a personal representative now that's going to carry out any of these affairs. This is typically going to be the same line of people serving in that financial, that general power of attorney. So just make sure that these are still the best people for you. And if not, we can update them. And in this case, if you have children under the age of 18, we still want to identify any guardians who would step in to provide that care if we're no longer here. So guardians will be in the will. They will also be in the general power of attorney. So make sure that they're the best people, and if needed, we can make adjustments to them or to correct a name or anything like that. Now, Article 6 is going to be several provisions and contingencies, mostly related to probate. Now, the only two I'm going to note for you here in 602, informal proceedings. When we write out wills, we always want to structure ourselves that the easiest version of probate that exists, that's the one that we want everybody to use. So in Colorado, as an example, that's called informal probate. So there's simply a mandate that if I have to go through probate, I want it to be the easiest version. And then what's 603 here? Fiduciary compensation. When someone is serving in this role and carrying out these responsibilities for us, the executor, the personal representative, if they have to go through probate, they are entitled to be compensated for that time and that effort. So this just really sets the stage for that. Compensation is pretty heavily regulated by statute. And so this really just gives them the ability to be compensated. And then usually someone like us, attorneys or accountants, are going to help them through that process. The rest of Article 6 are just going to be a number of legal provisions and contingencies. These are covered much more in depth in the full review video. In Powers of Fiduciaries, Article 7, we have just a fairly simple breakdown of all of the powers that an executor, personal representative, has to carry out our affairs. And so feel free to skim through that. These are dictated by statute. Article 8, similarly, is going to have a number of different provisions, these this time related primarily to taxes and finances. The one that I'm going to note for you here is Section 801, payment of debts and expenses. Of course, my executor, my personal representative, they're going to have the authority to resolve any debts, any taxes, any expenses that I've left behind. The remainder of this article is generally just going to be more clarification about specific issues that they could come up against. These are again covered more fully in the complete review video. At the very end of the document, there will be a few things. So if we create any specific instruction in terms of things like burial or cremation, we may have a section in here just telling people that. I will also refer you to specific handouts that we provide you during the estate planning process, where you can make those wishes a little bit more clearly known. We do recommend provide as much detail as you can in those types of handouts and give those back to us so that we can hold on to that for our files if anybody needs it moving forward. There will always be a definitions section, and it can be fairly lengthy, so please reference it for any terms that you're unfamiliar with. And then finally, what is Section 903 of this document? Contest is a clause that prevents people from being able effectively to fight. It makes sure that if a problem comes up in the future after I'm gone, that people can't go and just start battling in litigation for months or for years and bankrupting the estate. So there's specific situations that are identified here that if the beneficiaries do any of them, they will essentially be disinherited and they will lose everything that they otherwise would have received. It's very effective. It is authorized by statute and it prevents a lot of potential conflicts later. So in this document, please take your time, review the document, make any notes. If you want a more complete review, like I mentioned, go and watch that full video that's on the website. Otherwise, thank you, and then please feel free to proceed on to the next videos.